All right, Mr. Hunt Palmer, can you hear us? We can't hear you.
How about now?
All right, good.
Thank you.
And Ms. Latus, can you hear us?
Yes, sir.
All right, thank you. Today's proceedings before the Board of Disciplinary Appeals are called to order. As we announced in our order of October 22nd, 2024, today's hearing will be heard through remote connection through Zoom. If for any reason you get disconnected or have technology issues that prevent you from accessing the hearing, please let the BOTA staff know. BOTA staff can be reached by telephone. I'll give you their phone number if you want to write it down, 512-427-1578. That number also appears at the bottom of the BOTA website if you need to find it. Today's hearings will proceed generally in the same manner as they would in person and in the Supreme Court's courtroom. Please treat this Zoom meeting as you would a hearing in that courtroom. Today's proceeding is also being live streamed on BOTA's YouTube channel, and the recording will remain there. The recording will also be posted to BOTA's website. Any other recording is prohibited. All right, we're now ready to proceed with today's hearing. Today's hearing is being conducted by a panel of the board pursuant to BOTA Internal Procedural Rule 104A. I will begin by introducing the panel. I am Judge W.C. Kirkendall from Seguin. I'm the chair of BOTA, and I'll be presiding over today's hearing. Joining me are the vice chair, Jason Boatwright from Dallas. Jason, would you wave your hand so the parties can recognize you? And board member, Arthur DeAndrea, who lives in Lubbock. Arthur, thank you. BOTA staff are also present in this Zoom meeting. We have provided counsel and parties with a set of instructions and guidance for remote hearings, as well as instructions and guidelines for BOTA proceeding generally. We expect that you have reviewed these instructions and are prepared to comply with them. A few brief reminders. The board has instructed the parties and counsel to submit electronic files of any potential exhibits in advance. Those exhibits are not yet in evidence. They must be offered into evidence admitted by the chair in order to be considered and made a part of the record. If you wish to offer an exhibit that was not submitted previously, you must request leave to do so. We have screen sharing available on this Zoom call. You may request authorization to use screen sharing to display exhibits after they've been admitted, but the document shared must be identical to the document in the record. We also have breakout rooms available, and you may use a breakout room to confer privately. Breakout room discussions cannot be seen or heard by the board, and they will not be recorded or live streamed. You may make use of Zoom's private chat feature, except that counsel and parties may not use the chat to communicate with witnesses about their testimony. Please do not upload or share any files through chat unless invited to do so by the chair. Please do not message board members through chat. BOTA will not record or retain any chat messages. Remember that Zoom will pick up any background noise, so please silence any notifications on your device. And please, if you have a dog in your room, please silence that dog too. Before speaking, please make sure you're not muted. Any pro se party wishing to present testimony must be sworn in as a witness and subject to cross-examination. We do have a court reporter present, and she is making the only official record of today's proceedings. We're now ready to proceed with today's hearings. Call case number 69924 in the matter of Tara Eden Latus, a reciprocal discipline case. Would the parties and counsel state your appearance for the record, Mr. Hunt Palmer?
Yes, thank you, Mr. Chair. Richard Hunt Palmer for petitioner.
All right, and the respondent, please.
Tara Latus, the respondent, pro se.
All right. Are you ready, Mr. Hunt Palmer?
Yes, Mr. Chair.
You originally indicated you wanted about 5 minutes to present your case. Is that still correct?
Yes, it might go to 7, but that is still correct.
We'll give you that much latitude. Do you intend to call any witnesses?
No, Mr. Chair.
Ms. Latus, are you as the respondent ready to proceed?
Yes, sir.
Do you have any estimate of how much time you need to present your case?
I really don't know, maybe 5 minutes. I'm not really sure exactly about what I'll be asked and everything.
Do you intend to call any witnesses?
No, just speak for myself.
You intend to testify?
I'm not, I apologize. I'm not a litigator, so I mean, I don't mind being sworn in and everything being under oath, or if that's what it means.
Well, if you're going to tell us anything that happened to you, you need to be under oath.
Then yes, sir.
All right, would you raise your right hand? Do you solemnly swear or affirm that any testimony you may give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Do you have any other witnesses?
No, sir.
All right. All right. I'll remind the parties this is a reciprocal discipline matter, which is an evidentiary hearing under the Texas Rules of Disciplinary Procedure. The commission bears the burden of proof, and the respondent must prove any defenses raised by her pleadings and they must be proved by clear and convincing evidence. All right, Mr. Hunt Palmer, do you wish to make any opening statement, or would you prefer to go directly to your evidentiary presentation?
Mr. Chair, I can go directly to my presentation.
All right, you may proceed.
Thank you, and may it please the board. This is a reciprocal disciplinary matter brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure. The case is predicated upon a stipulation to discipline pursuant to CRCP 242.19. That's out of the state of Colorado. A certified copy is attached as Exhibit 1. I'll move to admit that into evidence shortly. It's also predicated upon an order approving stipulation to discipline under CRCP 242.19C that has been previously marked and submitted as Exhibit 2 for petitioner. And finally, it's predicated upon the affidavit of Blake Hawthorne attesting to Ms. Latus's licensure to practice in Texas, which is currently inactive. At this time, with those three exhibits, I'd like to go ahead and move before I proceed to enter them into evidence as Exhibits 1 through 3.
All right. Do you have any objection, Ms. Latus?
No, sir.
All right. 1 through 3 are admitted.
Thank you. Under Part 9, through Exhibits 1, 2, and 3, the petition both establishes this court's jurisdiction to hear this matter, and it establishes its burden of proof to show that reciprocal discipline is warranted in this matter. Ms. Latus received a 3-year suspension in Colorado. The rules that are cited in Colorado are of the same kind and quality here in Texas. There's no reason that the imposition of identical discipline, a 3-year suspension, is unwarranted based on either the rules underlying her suspension or on any of the procedures. Ms. Latus, in her response and in her exhibits A through E, provides 4 primary reasons why reciprocal discipline is not warranted in this matter. I'd like to briefly discuss those and why they do not meet her burden of proof, which is clear and convincing evidence to establish any defense under Rule 9.04 of the TRDP. So the first point she raises, really the first 3, deal with, and this is in her response, they deal with the kind of underlying situation that led to her sanctions. First is that she claims that her clients filed objectively false affidavits with Colorado in support of their complaint against her. She asserts that her clients made extortionistic threats against her through emails and through the complaint process itself. And she argues that the Assistant Regulation Counsel provided the false affidavits to the Colorado Supreme Court, knowing full well that they made material false representations. She doesn't tie any of these three in her response to a particular defense under 9.04, though she does note in her fourth point that she did not receive due process. They may be considered under that, but I don't think that they fall under any particular category. And the primary reason is that she stipulated to her discipline. She does say in her response that she has a complaint against the attorney for that process that is still, I believe, pending in Colorado. The fact that that has not been adjudicated or resolved is further reason that this board, well, that Ms. Latus cannot meet her burden to show any defense under 9.04. I would like to address her due process argument. She makes three. The first is that her personal circumstances and her mental health records, they were initially not considered during the settlement and the process of her discipline. She also notes that the Assistant Regulation Council refused to even consider some of the stipulations she was willing to make towards a lesser sanction. Now, both of those considerations are disposed of by the Exhibit E that Respondent provides along with her response to be considered into evidence. That exhibit is a list of stipulations. It's Exhibit 2 to the stipulations that were provided to the court to support the stipulated discipline. And they note that as mitigating factors, her personal circumstances and mental health were considered in the discipline process. Finally, for the due process argument she makes, she notes that the Assistant Regulatory Council refused to depose her clients or call them as witnesses. And I believe that doesn't really apply because in her stipulation to discipline, she waived her right to a hearing. But in any case, due process wouldn't require that a prosecuting attorney, civil or criminal, depose or call witnesses that the opposing party defendant could call or depose. For all those reasons, Ms. Latus has not met her burden to show by clear and convincing evidence that any defense under Rule 9.04 applies, and therefore reciprocal discipline is warranted in this matter. That's all. Thank you, Mr. Chair.
What sanction are you requesting, Mr. Hunt Palmer?
Well, the identical discipline in this case would be a 3-year suspension, Mr. Chair.
Any questions of CDC representative?
I have one, Mr. Hunt Palmer. What's the Texas analog of the Colorado rule? I believe it's 1.15A and 1.15B that she was adjudged to have violated.
It's the failure to put funds into, let me double check this, but from my notes off the top of my head, it's the failure to utilize an IOLTA account or to deposit client funds in an IOLTA account. And if that's wrong, I apologize. I'll have to refer back to my notes on that.
That's fine. Thank you.
All right. Anything else? All right. Ms. Latus, you ready to proceed?
Yes, sir.
You may.
I'd like to first start out with, I'm not claiming I didn't negligently violate any rules. I'll tell you the ones that I know I did. But I definitely never stole anybody's money. I never accepted any money in advance for services not yet rendered. And I'll go through the exhibit and get that admitted in a moment. I definitely did practice California law without a license. And when it had just been suspended for non-payment, I mean, I don't know if it matters, but my husband at the time, going through a divorce, abusive, all this horrible stuff, he was ordered to pay them, and I negligently didn't. I avoided it, and that was a horrible mistake. And then I also, on the letterhead, held out that I was licensed to practice law in Texas, California, and Colorado when I was inactive in Texas, and I was again suspended for failure to pay at the same time, almost, for California and Colorado. And I also failed to give them a timely invoice, and that's horrible. It's inexcusable. I'm not going to say that what I was going through with my kids being kidnapped and all that kind of stuff for all those many, many months was an excuse. I should have just not been practicing. And I made that mistake. I did give really great legal advice, and I think their emails are far from grateful, and they changed their business model. And so I do believe I did something wrong. I just didn't in any way take their money and steal it from them, and any advance payment. All the services had been rendered, and I guess I would just like to go into the exhibit A, which and then submit that into evidence, if that's the proper way to do that. That's the email exchange from August 22nd through 26th.
You previously submitted that
Yes, sir.
in respondents exhibits, exhibit A.
Yes.
Do you have any objection, Mr. Hunt Palmer? Do you have any objection to the admission of exhibit A?
Pardon, no objections, Mr. Chair.
All right, it's admitted. Exhibit A only.
I mean, in that email exchange, they clearly in August acknowledge that I've been providing them services, asked me to continue to provide them. They reject the advance retainer blatantly and say, no, we don't have that money right now. Could you please continue to provide us services at an hourly rate? And when we can come up with the funds, we will send that to you. And they're happy with me. They changed their business model in that email, and they completely revamped it for my prior legal advice I'd already given them, and asked me to set up another meeting with them, which did occur. And I told them, hey, it's going to take me, I've already spent a lot of time on this. It's going to take me hours to do that. Is that okay? And I even gave them at least 5 hours to even prepare for that with the new changes to their business model and do the research and everything. They agreed and were grateful and said they'll get it to me as soon as they can. And that email, the Attorney Regulation Council refused to even consider it. I brought it up multiple times in the negotiations, and he said, nope, in their affidavits, they didn't engage you until October 27th, and you didn't provide them any services after that, so you stole their money. And he just said, that's what their affidavit is, and that's what they've said. And anytime I try to bring up that email exchange where it's just the opposite of their affidavits, he's like, nope. And he also, all along, he said, the only thing I get is revocation. And even with the stipulation, first of all, he of course he refused. I know that I didn't have any money to call them. And if that's their only evidence, like, why wouldn't he just call them? And I think he made a mistake and filed in that initial interim proceeding. He filed those affidavits and had never even looked at the emails. And because I didn't even say anything about it until after it, and he made a mistake. I mean, he should have known that those were false affidavits and should have questioned them. And I read all the questioning in the record of what he did. He never even mentioned to them, well, what about this exchange? Even after the fact, he never did it. And that, I mean, I don't know what the defense is there, but I just don't see how even the stipulation, I kept saying, look, I need to, can we at least put in there what they said in those emails, that they asked me to provide them services, to continue providing them, and to bill them and take it out of the payment as soon as they can get it to me, and to please keep providing services until then. Obviously it's horrible I mean, I'll never be able to practice law again, even if I get my license. I mean, that says I stole clients' money and I didn't. And then anyway, so I mean, they got more than $7,000 worth of free legal services. I gave them their money back. I was scared about what they'd continue to do after the extortion where they're demanding every bit of their money back because they found out I wasn't licensed and they're going to report it to the other boards. And well, we haven't reached out yet, but if you give us all your money, all the money back, then we won't do that. And they can't ask for all their money back when they have emails saying, I mean, without it being a legal threat to report me for being unlicensed. And anyway, so I guess I should enter that exhibit of their extortionate emails. That's exhibit C in my exhibits that I submitted. I think, or maybe it's D. I'm sorry, it might be D. A is their email exchange from August, and then B are the affidavits. I would like to go ahead and submit those two. The B, the false affidavits, and then C is the invoice. D, I'd like to submit all of these. D is the extortion emails, and E is just the summary of all the traumatic things that I was going through at the time with the abuse from my ex-husband, my children also being arrested for abusing me, and they were kidnapped by him. And eventually the judge ordered that if he does it again, he'll go to jail. So that finally stopped. And then my mental health records and everything. And all along, when any time I'd ever try to talk about any of it, he would just say things that were completely wrong. The attorney for Colorado, he would say, no, there's no way, your mental health history or anything that's happening with the abuse and everything can be admitted. The only thing you can do is hire an expert to speak to that. And then sure enough, when it gets to our status conferences, the judge is like, no, she needs to be able to argue her case. And he ordered mediation. And the mediator insisted, no, of course, all these are mitigating factors. And also he insisted that there should be stuff about what is in that August exchange. But eventually he would never let me, that attorney would never let me put it in there as part of the stipulation of what happened. Anyway, there's the invoice of everything, and they've done this in the past. I should have never taken the client on. One of the clients, he still owed me, I don't know, $3,500 where he did the same thing. Oh, please, I have it in emails where he's like, oh, please keep providing me services and we'll pay you as soon as we get the money and we get funds. And I shouldn't have taken the client on, but that was my fault. So I don't know what the right provision under 904 looked like. All of them applied, but I guess not. I don't see how the whole case is based on false affidavits. In their affidavits, they expressly state, we never engaged her to provide us legal services until October 27th when we paid, and she never provided us any services. And that we talked to her before just to see if we liked her. But that's directly conflicting with their express email saying, please bill us at an hourly rate. We don't have the money yet. And I even want to give them time quotes. Okay, sorry. Yes, sir.
And let me ask you a question. Why in the world did you stipulate to the sanctions in Colorado if you had these objections to the evidence and a belief in your innocence?
The attorney said, all you will get is revocation if you don't sign this. And if you go to hearing, I'm not going to call those witnesses, and I couldn't afford to get anything. I mean, they're out of state, and I don't have that money. I mean, there was no way for me to do it. And I thought, I mean, the emails speak for themselves. I didn't see how in the world it makes it. But he said that, no, if you go, you're going to get revocation if you do the hearing. And I've got many emails from him saying that. So that's not like me making that up. But
Do you have anything else?
no, Your Honor.
You're finished with your testimony?
Yes, sir.
Do you have any questions, Mr. Hunt Palmer?
I do, Mr. Chair.
Go ahead.
Ms. Latus, will you explain what the current state of things is with your complaint in Colorado?
The head has just said it's tabled. That's all she said.
Do you know if there's a particular timeline that has to be resolved or dismissed?
Not according to them.
Okay, I have nothing further. Thank you for your time.
All right, any questions from any Board members for Ms. Latus?
I have a couple. Ms. Latus, do you have a disciplinary proceeding pending against you in California?
No, I notified them and I haven't heard anything.
Okay. And in your response to the show cause order, I believe you raised, you raised a bunch of defenses that probably don't constitute defenses under Rule 9.04, but maybe due process does. Can you identify which specific defenses you're asserting in your response? And if you could just be specific and try to be real focused on exactly what your defenses are without going into what somebody did to you or anything like, if you could just be specific about what your defenses are, I'd appreciate it. Thank you.
The attorney for Colorado filed a false affidavit that he knew or should have
I
known.
mean, what I mean is the defenses that are listed in Rule 9.04, and if you can't do it, that's no problem. I'm not here to
Let me
just to string this out. But just
yes.
the defenses that are listed in 9.04, if you could be specific about that, that'd be great. If you can't, that's all right too. Just can you identify the defense?
Maybe a little on A, so lacking in opportunity to be heard to constitute a deprivation of due process. I mean, every single time I tried to discuss with him anything about the defenses, like the mitigating factors and that email.
Are there any other defenses besides
Okay.
A?
Okay, let me see. There was such an infirmity of proof establishing misconduct in the jurisdiction as to give rise to clear conviction.
You stipulated to that. So what about C, D, and E?
C, definitely a grave injustice for me being punished for stealing a client's money when they asked for services and agreed to pay for them. I don't know how that could be a worse injustice, but
thank you. And is the misconduct for which you're disciplining Colorado, is that professional misconduct here?
yes. So they alleged that the allegation is that I stole their money, never provided services, and took advance payment for services not rendered.
Okay,
and
so
their emails say the opposite. So
okay, all right, that's good. Thank you.
Let me make sure that I haven't hit any others. Okay, so E wouldn't apply because it's the same rule and essentially the same in both states.
All right, thank you very much.
D and E, D and E don't apply.
All right, you have a question, Mr. Hunt Palmer?
Yes, Mr. Chair, I just had one follow-up based off of member Boatwright's questions. Ms. Latus, do you have any clients in Texas at all, or do you practice in Texas or plan to?
Oh, not until all this gets resolved. And no, I don't have any clients in Texas or California or Colorado. I'm teaching full-time as a high school calculus teacher.
Thank you. That's all, Mr. Chair.
Any other questions? All right, do either party have any other evidence or argument?
No, Mr. Chair.
All right, nothing else, Ms. Latus?
Other than that, I think it's clear and convincing evidence from their emails that they asked me to provide services. They were happy with them. They requested it to be taken out of their future payment, which was not an advance retainer. And by their own designation, they rejected paying up front before anything. And it seems like a grave injustice that if someone can submit false affidavits directly in conflict with their own words and outright lie, and I lose my license.
All right, thank you both. This will conclude the hearing today. The board will take this case under advisement. We'll notify you after decision is reached. Thank you, and you're both excused, and I'd ask the board members and staff to remain, but y'all may leave.
Thank you.
Thank you.